start with the First Amendment. The First Amendment has got the establishment of religion. Well, we know that marijuana is a spiritual element. Therefore, the government cannot fuck with our sacrament. Prohibiting the free speech, well, we know that the government uses conspiracy laws to bust people when they talk about growing their medicine. How about assembly? You just heard from the last panel how the city of Los Angeles ordinance fucks with the right of assembly, that a certain number of patients and no more may join together to cultivate. That's just the First Amendment. And we didn't mention the right to petition the government for redress, which we know they use lists of people who petition the right of the government. They use lists to prosecute and fuck with such people. The Second Amendment is pretty obvious. Keep and bear arms. Well, the federal government's already announced that if you're a marijuana patient, your Second Amendment rights are toast. You can't go buy a weapon. You can't protect your family farm if you are a marijuana patient. And in fact, the federal government will double any possible penalties against you if you're growing or selling if you happen to have a gun. So there is no Second Amendment, there is no First Amendment. You see where this is going? Third Amendment, no soldier shall be quartered in your house. Well, we don't have soldiers quartered in our houses, we have cameras pointing at our houses. Fourth Amendment, to be secure from search and seizure, forget it. Reasonable suspicion, oh, I smelled marijuana in the car. There's no requirement anymore that a member of the police go to get a proper warrant signed by a magistrate on probable cause. We know that amendment's gone. Let's talk about the Fifth Amendment. Well, one part of it is double jeopardy. It's not supposed to be put in jeopardy twice. What about these people who are being prosecuted federally as well as state? That's double jeopardy. And not to mention due process of law, or when they close down a collective and they take our property without due process and without fair compensation. So the Fifth Amendment goes. The Sixth Amendment for speedy trial, that's about the only thing that you need your attorney to demand. If they've got balls, they're going to take a speedy trial and they're going to catch the people with their pants down and show they have no fucking case. Excessive bail, unreasonable fines in the Seventh Amendment, forget it. They put people in worse jail for marijuana than for murder and rape. It's a travesty and a joke. And of course, the prison population are used as low-cost employees as part of this prison economy. It's a crime. It is cruel and unusual punishment. So you can forget about the Eighth Amendment. The Ninth Amendment, that the enumeration of something in the Constitution shall not deny if it's otherwise retained by the people, and then the 10th of the states. Well, that's exactly what they've been ignoring. This is a 10th and 9th Amendment issue. We do have rights. We are a state that is a delegated thing. The federal government is a delegated power. Our state is superior to that delegation. So we've been a victim of the big lie. And so we don't have the rights we thought we had. And it's like the Matrix. And they say marijuana is not medicine, but if you look online, all the way back in the 20s, you could get cannabis indica or cannabis sativa from the major drug companies. And we know we've seen the information. So it took away our medicine. Now, when you go online and check out the medical uses of marijuana, the history of it, it goes back to 2900 BC with the Emperor of China. And it's in every culture. Who do these people think they are, and who do they think we are? Okay, so that's why I'm suing the city of Los Angeles, and we're currently in litigation with them. That's why I'm suing Long Beach, and we're currently in litigation with them. San Bernardino, Riverside, Kern. Any place that they are not allowing collectives to get a license, they need to sue. They need to sue the city, the collectives, and the patients need to get together. You know, we talked about this a long time ago, Bruce. That's a great question. You know, it relates a little bit to the question of, you're familiar when they made alcohol illegal, and then they made alcohol legal again. In both of those instances, there was a constitutional amendment required. So they acknowledged in that circumstance that they couldn't take away the rights of the people to have alcohol unless the change went all the way up to the level of a constitutional amendment. And the same with giving back the right, or taking back the right at the end of Prohibition. So my answer is, they could not. It's been an illegal thing they did from the beginning to try to take away marijuana from the people without a constitutional amendment. And since they never did it in the first place, it was illegal in the first place. Not to mention, when you study the group here in America that made it illegal, it was done by a bunch of bigots and racists. You know, they claimed that there was racial issues. And then it was also done without the participation of the AMA. The only witness that was from the AMA testified against it, and the congressman just shut him up because they wanted to ram this thing through because of the fact that cannabis is the ultimate medicine, the ultimate paper, the ultimate fuel, the ultimate fiber, it's the ultimate plant. And so, just like Jack Herrer explains, this is the result of total hypocrisy and bullshit. What's interesting is that America shoved it down the throat of every other country because of our hegemony after the war.
Says that if you have 6 mature or 12 immature plants or 8 ounces of bud, not shade, but bud, that's supposed to be protected from any arrest. However, again, you have to have a county identification card to avoid the police officers just taking your letter and ignoring it. Okay, so that's another one. Everybody knows about county identification cards, but that's the type of identity and proof that you can have that will protect you against an officer busting you, taking your dope, your weed, your sacrament, and also giving you a ticket or otherwise. If you have a county ID card, you've got to recognize that county ID card. So that's the only right you have. Unfortunately, the rights are as good as what the courts have given you, and that's it. You got to think more than that. There's no right to just say I have my medical marijuana. I have no right not to be seized from me except under those circumstances.
It is so hard for the patients to hear.
Let me further give you a deeper understanding why there can't exactly be a right yet. Okay, because federal law, which supersedes, says that this activity is a felony, therefore our state has carved out a defense, but not an affirmative right. And that's how it evolved.
Yeah, absolutely.
You know, okay, so yes, we do need a right. Now, what's interesting is in the recent case of county versus alternative, which has just been taken up on appeal, so it's no longer the law, we can cite to a judge, but it's going to be part of the mix of what the Supremes are working on right now here in California. In that case, they really expanded it to being a right. They really, that's why it was such a great case, and we won against Long Beach using it. Because it really went great, it went far. It said that 600-foot rule that came in, the 600-foot rule said that acted to amend SB 420 to permit dispensaries without a doubt. It was a great, and deliveries, because of course it mentions mobile retail outlets. And so therefore, in that case, we're talking almost to the level of rights. So we do need a case that says that, and then it becomes the law.
I have the case law, but it's a federal case. It came out in 2011. It was not a marijuana case, but what it spoke to is, if you look at it, it spoke to an individual's right to basically force their case back into states and let a state adjudicate. So the long story short, it was a assault. This lady basically used a caustic chemical and threw it at her ex-husband or boyfriend's girlfriend. The state originally started prosecuting because the feds came in and said it was a terrorist act. They did a federal case, and on a 9-0 overturning of, not overturned the case, but basically said that their attorney was right in saying, because there's dual jurisdiction, that she had already worked out a deal and everything else, that the feds had no right to take the case over. And so there's a lot of talk going out It's Caroline Bond versus the United States, B-O-N-D. It's a good case, and I know that from the activist movement and some of the stuff that I do with LEAP, is we've talked about how that may be a way to regain a states' rights portion, and you know, I'll talk about this a little bit on the Justice Panel. But I think that it could be potentially down the road used to say, hey, look, get the federal, because what we need to do is end the CSA and let states decide how they want to enforce their drug laws. Period. Get the feds out there is what our goal is.
Yeah, but what about when
FTF.
when the city's
Bottom line,
offensive?
FTF. No, that's great that there's a case saying that the feds are overreaching, and that whole thing with the Patriot Act and everything else, it just gives the feds even that much more fodder for going after us.